Welcome back. We're going to continue along into section 1. Like before, I'm going to read a little bit from the book and then we'll talk about the things that the book covers. The judiciary's role in American government. The book notes, as you learned in chapter 1, the body of American law includes the federal and state constitutions, statutes passed by the legislative bodies, administrative law, and the case decisions and legal principles that form the common law. These laws would be meaningless, however, without the courts to interpret and apply them. This is the essential role of the judiciary, also known as the courts, in the American governmental system, to interpret the laws and apply them to specific situation. The book then tells us to turn to the next page, which is Insight into Ethics, a side section that we'll talk about for a little bit. There are two elements that we crossed over that I want to discuss. One is the common law system. The common law system is the prevailing court system in the United Kingdom. The United States adopted essentially a common law system, being that it was mainly a British colony, adopted the common law system to help its courts as it passed through. Now, the United States no longer has a pure common law system, but we do have some elements that remain. And what's important about that? Well, one of them is precedent, and the word is P-R-E-C-E-D-E-N-T. Precedent is basically when a court uses a previous decision it's made on a similar topic to apply the same sort of ruling. Now, what do I mean? Well, let's think about a situation where you have two neighbors, and one of the neighbor has a tree with a branch that's basically climbing over into the neighbor's yard. Well, the first guy decides to cut down the branch because he doesn't like it in his yard, and the tree dies. Well, of course, the second neighbor is then mad because his tree's dead. He sues in the court system, and the courts decide, heck, let's make the guy who cut the branch have to pay for half of the tree replacement. Whether it's fair or not, that's not really for us to decide. But what happens is, let's say a year later, a similar situation arises. Two neighbors, a tree, and a branch, and the same exact scenario happens. Precedent is the courts then will just look at the previous same exact decision they made a year earlier and apply it into this current situation. During class, we'll go and explore this idea even further. I just wanted to briefly mention that sort of element. So the common law system and the term precedent, P-R-E-C-E-D-E-N-T. Make sure to notes on that because we'll be discussing them in class. Now, this section is extremely important here at Insight into Ethics. The United Court System has thousands and thousands and thousands of rulings throughout the year. There's so many courts, and we'll discuss the number of courts and the different kinds throughout the United States that make decisions. Now, each and every one of those decisions is a precedent. Basically means it's not controlling on future decisions before the court. We'll read a little bit from the section. The notion that courts should rely on precedents to decide the outcome of similar cases has long been a cornerstone of U.S. law. Nevertheless, the availability of unpublished opinions over the internet is changing what the law considers to be precedent. An unpublished opinion is the decision made by an appellate court that is not intended for publication in a reporter, the bound books that contain court opinions. Courts traditionally have not considered unpublished opinions to be precedent, binding, or persuasive, and attorneys often have not been allowed to refer these decisions in their arguments. Now, interestingly enough, and I'll be posting an unpublished decision on ingrade.com. I want you to read through it. Why do I want you to read through it? Because that court actually relied on one of the articles I published. So we'll actually be talking a little bit about that court case, but it is an unpublished opinion. Now, what's changing is, and this section notes, is that a lot of court decisions, even though they're not being officially put together in the court reporters, they are being published online. And that's how you'll be able to see the unpublished decision that mentions my article. So why are they being put online? For the same purposes as anything else, so people can read them and find out what's going on. Now, what makes this interesting is now courts sometimes are allowing the idea to at least introduce unpublished decisions into the arguments being made by attorneys, and that's what this section discusses. And so there has been this move about all these thousands and thousands of unpublished opinions having some sort of effect, even though it's not as strong as what we call precedent decisions. So read through this section and you'll understand exactly a little bit more, and we'll talk about it. And make sure, like I said, to read through the case I'm going to be posting online that is also an unpublished decision. Now let's move into section 2, which is basic judicial requirements. It's on page 56. Before a lawsuit can be brought before a court, certain requirements must be met. These requirements relate to jurisdiction, to venue, and to standing to sue. The book examines each of those, and we shall as well in point. Now, what do I mean by being brought before a court? Basically, what happens if somebody has an issue with you or your company, then they want it resolved, or you have an issue with somebody else or their company, you can go ahead and sue. You file what's called a complaint with the court system saying, hey, this guy has done me wrong, and these are the reasons why, under the law, he has done me wrong. An easy example is a breach of contract. Steve promised to pay me. Steve never paid me. Here's the contract where Steve had to pay me. Basically, give me my money, court, and also pay for my attorney, please. So these are the sort of elements how we go before the court here in the U.S. system. There's multiple other ways and multiple other methods, but the complaint is our normal common element, basically saying, hey, court system, I need my money. This guy's not paying me, and I know he has the money. So let's talk about jurisdiction real quick. Jurisdiction in Latin means law, and diction means to speak. Thus, the power to speak the law is the literal meaning of jurisdiction. Before a court can hear a case, it must have jurisdiction over the person or the company against whom the suit is brought, which they call the defendant, or over the property involved in the suit. The court must also have jurisdiction over the subject matter of the dispute. Now the book notes, and I'll mention each of these briefly, different sorts of jurisdiction. But let's take another one of our quick little breaks, and then you can move on to the second video.